Direct Connection is made by MPT to serve all of our diverse communities and is made possible by the generous support of our members. Thank you. Live from Maryland Public Television, this is Direct Connection with Jeff Salkin.
Hi, everybody, and thanks for tuning in for Direct Connection. I'm Yolanda Vasquez. According to a survey by AARP, 2 out of every 5 Americans age 45 and older do not have a will. It is the most basic estate planning document, but for many, the question is, where do you start? Joining me now to answer that question and many more is David Pessin. He is the founding member of PK Law. David, it's an absolute pleasure to have you here in our studio tonight.
Thanks for letting me come.
So what do you think about those numbers, 2 out of 5? I actually thought the numbers would be higher based on conversations I've had with people.
I'll tell you what, you hear all different kind of numbers, but it's probably worse than that, because a lot of people that say they have wills that they made 30 years ago when their kids were born, stuck them in a safe deposit box, and that's where they remain. Probably valid, but not useful.
What is the main deterrent? Is it the cost? Is it I'll get around to it? Is it you don't think you really need it? All of the above.
Okay, a lot of people think nothing's changed. Okay, that's the #1 response you get. Well, nothing's really changed. Nothing they know of has changed. The tax laws changed. The laws about wills have changed. The execution formalities may change. Their children certainly changed. Their wealth changes, but to them, nothing's really changed. Right. I think the other one is there's a sense of having to address your mortality when you go and have a will.
This is what it is for my mother.
And
it
gives some people the willies to have to think about. You know, so what would the disposal of your remains be, Mrs. Smith? And they're like, is that, you mean cremation or burial? And that's stuff they just don't want to talk about.
So those are some of the reasons. You are a wealth preservation attorney. What exactly does that mean, and who are some of your clients? You know some ballers, I'm just going to say.
Yeah, well, I tend to represent people from all walks of life, some at the highest degree of celebrity, and some people are just regular folks like the rest of us. So the wealth preservation is sort of, you know, some people think it's euphemistic for estate planning, but it's really not. You know, 30 years ago when I started this, people talked about business planning and estate planning. But in the last few decades, there's been an evolution to being really concerned about not only the things about what happened when we die, but what happens when we are alive. You know, what are the erosive factors that can diminish or deplete entirely someone's wealth, something that they've worked for their whole lives. And that could be great wealth, or it could be just stuff that's important to you. You know, so wealth preservation embraces what happens if you go to a nursing home, what happens if you get a divorce, you know, and you're remarried late in life, what happens in the probate process, what happens when your business now is in a mature state and you're older and you're thinking of retiring and your kids don't want to take over the business. That's a loss of wealth. That's money left on the table. So it is sort of a holistic way of looking at the things that can diminish what we've worked for our whole lives.
What happens if you die without a will?
Well, technically that's called intestacy, and the General Assembly of the state of Maryland gives you a will. And it could be very, very surprising to people what the law is, depending on the nature of their family. I had a lady that came in one time, and her husband died, and he didn't have a will, and she found out that she gets to share the house she was living in that her husband owned with her mother-in-law.
Oh, my
That's
goodness.
intestacy.
So that right there is a reason to get a will done. Let's go to the phones right now. We have Lisa on the line from Allegheny County. Lisa, go ahead.
Hi, I have a living will and as well as a regular will, and from another state. Is that valid here in Maryland, and how often should I review it?
Okay, good. That's a really good question, Lisa. It's valid because state to state, the laws of another state are typically respected. So if it's validly executed in another state, it's not invalid here. But that doesn't mean it's fully useful. For example, particularly you mentioned your living will. We tend to call those medical directives. And the form and content of a medical directive is probably one of the most variable things state to state. And while it's valid, you certainly don't want a doctor in a hospital looking at a medical directive that talks about California law when you're trying to have him make a decision here in Maryland. Wills can present some unique problems. For example, Florida requires a higher degree of formality in the execution of documents than Maryland does. So if you have a Maryland will, you go to Florida, you have to prove who the witnesses are, and they may be dead or gone. So it's probably a good idea when you move from state to state to have things reviewed, revised. I think a larger question is how often, and I think that a pretty good rule of thumb is every 4 or 5 years, just to make sure if things are good, they're good, and if things have changed, they need to be fixed.
Good, because that was one of my questions anyway. We're going to keep the phone lines going. We have Susan on the line from Baltimore County. Susan, go ahead.
Hi.
Hi.
My health care directive and my regular will is registered in Baltimore City because that's where I lived when I filed it. I'm now living in the county, and I think everything is copacetic, but just wondering.
Yeah.
You know, registering wills is something that some practitioners really believe in firmly, that they're going to take their original will to the Register of Wills office and have it put on file there. So there's some degree of certainty about what the will is, who has it, and where it is. Other practitioners are a little more lukewarm about it. I probably fall in the second category. You haven't got a major problem because your will is registered in Baltimore City. It's still, valid. If you're so inclined, I'd get a copy of it and I'd register it in the Baltimore County Register of Wills, which incidentally is one of the best state agencies I've ever dealt with. A little plug for them. They're great.
We're going to get into that, where you should register your will. We're going to still keep the phone lines going. We have Tim on the line from Howard County. Tim, go ahead.
Yes, if I'm looking for a lawyer to do my will, what kind of certification should I look for in their practice?
Great question. Thank you, Tim.
Okay, Tim. There are a couple good starting points. One is Martindale-Hubbell is a rating service, and they do ratings by lawyer categories. Top rating will tell you a practitioner who's been at it a while, well-respected among his peers. It is a peer rating. Tim, there's really no good substitute for word-of-mouth referral. Do you have a CPA?
Tim's probably
Tim's
gone.
gone?
Okay, yeah, he's
well,
listening.
If he has a CPA or a financial advisor that he's worked with for a while, it's a really good place to start.
You and I were talking a second ago. What about the online services? I won't name any names, but you know what I'm talking about. Is that a good place for a low-cost, affordable way to do a will?
It's a very good way to gather information. It's low cost, and you'll get a sense of what things should be.
You're not really a big fan of it, only because it's very generic.
I'm really not, because my approach to this is to ask a lot of questions.
Right.
When someone comes to see me, I spend probably the first 40 minutes asking questions about who they are, what they've done, where they're going, what their future is. And then I want to know about the kids. Are they trustworthy? Are they in good health? Do they have good marriages? Are they financially stable? Would they be a good steward of your assets if you became sick or disabled?
You can't get that online.
You miss the aesthetic and important emotional implications of these things.
Let's go back to the phones. We have Elizabeth on the line from Loudoun County. Elizabeth, go ahead with your question.
Hi, I'm happy to be working on that right now myself, and one of the things that I remembered is nobody knows my passwords.
Your passwords. Ah,
Yes.
How does that play into everything?
I will tell you how. The best thing about being an old lawyer is you hire very smart young lawyers.
Okay.
And some few years ago, they said, all your trustee powers and all your personal representative powers in your will and in your financial durable power of attorney for use while you're alive, they should all have an express reference to intellectual property rights and electronic information and the ability to use the power of attorney to go get the password, to get access to those protected informations.
Yeah, because if you don't, you're not going to be able to get it. And there's probably so much information you need to know.
It's a hassle.
Yeah. Let's go back to the phones right now. We have Rhonda on the line from Howard County. Rhonda, do you have a question?
Yes. I'm been thinking about making some end-of-life decisions, and I'm thinking about moving into a place that has level A care, which means that you go in there and they provide meals, and, your insurance doesn't go up when you got to go into a dementia unit or whatever. And I would like to make something in my will that if I were to have dementia, I don't know my family members, and et cetera, that I would no longer want to be fed. I would like, I think that it's just normal nature that if you cannot feed yourself, then that's the time to go. If you're incapacitated totally.
Wonderful.
And nobody thinks you'll be able to come back.
No, great question. You definitely want to make sure that your whatever it is you want is being taken care of.
And is that legal?
Thank you. Does that fall, thank you so much for the question. Does that fall under the medical care directive?
Yeah, it does. It's precisely the purpose for an advanced care directive. We think it's a really good idea to have the following components. Number one is selecting healthcare agents who know what you want. Because it's, it's fairly well acknowledged, the medical communities, they don't love these things, and they sometimes don't honor them. So to the extent that you have appointed people that can advocate for you and know your wishes, that's great. Also, you want to empower them in the document to make end-of-life decisions. And what we do, I love this, in our advanced directive, we have an opportunity for people to express in their own words. They type it up, they get on their computer, they type up exactly what they would want under certain circumstances, and we append that to the document itself.
So let's go back to the phones. We have Doug on the line from Fairfax County, Virginia. Do you have a question for David?
Yes, I wanted to ask about revocable trust and how that ties to wills and what their guest thinks of revocable trust.
Excellent. David had it on his list of questions.
Doug, I actually love revocable trusts. I don't love them for every single person, but I use them extensively in my practice.
What is a revocable trust for people who may
revocable
not know?
trust is a will substitute. It's a trust that you make up in your lifetime with a trust document, and the document basically says, I hereby establish a trust, and I can do whatever I please with my assets in the trust because I'm the trustee during my lifetime. Should I become incapacitated, somebody else will come in and be the successor trustee to manage things. In the event that I die, and this is the keynote of a revocable trust, this is the raison d'etre, is to avoid probate, to avoid dragging all your assets through the courts. Now, if you have assets that are extensive or spread out or of substantial wealth or even of moderate wealth, and you want to make it easier for the people after you, revocable trust is a great tool. I'm a little dismayed about the way it is sold by practitioners sometimes as something that is compelling under every single circumstances. One size definitely does not fit all. But in general, I love revocable trusts.
What about trusts within, like under your will for your kids?
I love trusts.
Okay.
Trusts get me excited.
Okay, but talking to a lawyer, I love it. But what is it about trust that gets you so excited? What do you like the most about it?
I like how flexible they can be, how innovative they can be, how you can take a situation and use a trust to anticipate and solve problems in advance. We use trusts under wills, obviously for people who have young children.
Under 18?
Under 40.
Oh, okay.
If we're talking about listen, in this day and age, putting a large sum of money in a young 21-year-old's hands is tantamount to destroying it.
Okay.
It doesn't help them. It hurts them. I like trusts like that. Look, you can always get the money out of the trust. So if they're a worthy cause, good reason, trusts don't landlock money. Kid needs it for education, they need it for support, they need it for business. The trustee can make that decision as you would if you were alive. On the other hand, when the kid says, I want it for my education, and you find out the education is surfing in Costa Rica, the trustee might say, get a job.
Right, okay. So that's the benefit of having...
Obviously, we use them for special needs people, so they're not disqualified from public benefits. We use them for people who have had lifestyle issues, drug, alcohol abuse problem, and we're a little concerned about their lack of sobriety and good judgment. We use it for older people we want to leave money to. I have lots of athlete clients. They always want to help their mom out, but we understand that the moms get older, so we need some protection and governance.
Good stuff there. Let's go back to the phones right now. We have a Jim on the line from Prince George's County. Jim, go ahead.
Hello?
Hello there. Can you hear us?
Yeah, I can hear you.
Great. Do you have a question?
Yeah, I'm going through a process right now of trying to revamp my will due to a unexpected death of a girlfriend of a long time, and she didn't have a will. Luckily, she listened to me and wrote up a will a few days before she had surgery. But anyway, I had a power of attorney, a financial one, through my stockbroker, and so I'm doing that, and I'm just concerned about exactly what is a power of attorney, a durable power of attorney versus a regular power of attorney versus a trust, and that I'm trying to decide whether to redo my will as a trust or a power of attorney, or do I need to do both, or what?
Great questions. We will get to the definition of those for you. Thank you so much for the call.
Okay. You know, it's unfortunate. For years, we used the term durable power of attorney, and it was to distinguish something that really doesn't need to be distinguished anymore. It simply meant that if you became incapacitated, the authority granted in the power of attorney endured the disability. It's an archaic kind of rule of law. Now most statutes say that if you're incapacitated, your power of attorney is still good. So I like to throw that word durable out. I like to think in terms of financial power of attorney to distinguish it from a medical power of attorney. So a good comprehensive financial power of attorney addresses every single transactional event that could happen in someone's life and authorizes the people that you name, that you select, whom you trust, whom you have vetted, to handle those affairs in the most efficient and organized way possible. We should probably have a primary person and an alternate. We should be careful of picking people who are in poor health or have not demonstrated their own financial stability, but every single adult, and we start with when the kids go off to college, should have a financial power of attorney.
That leads to my next question. Who should you name as your executor, and can you name more than one, and how do you even work that out? Okay, again, one size does not fit all. You know, I've heard over the years, I'm going to name my oldest. Well, where's your oldest? Prison. Well, not a good choice. Okay, I'm going to name my son. Why? Because we name sons, not girls. Basically, what you're looking for and you can name more than one. In fact, you should name more than one, and you can name them to work together if they bring different things to the table, or if they have a cogent family relationship, or you can name them in a priority sense. But they should be organized. They should have demonstrated the highest order of integrity. They should have some basic understanding of financial affairs. They don't need to be a stockbroker, an accountant, or a lawyer, but they should have the common sense to be able to talk to a stockbroker, financial advisor, a CPA, what have you. Certainly, they need to have the age and health to be able to count on them to be there. Excellent. Let's go back to the phones right now. We have a call from Myra, Prince George's County. Myra, go ahead.
Hello.
Hello.
Yes, I'd like to ask a question. I don't have a will. I'm 78 years old. I'm not an American citizen. I am a green card permanent resident. I have a little bit of money left in England for my sister when I die, and I want to be cremated and taken back to England. But the thing is, I don't know how to, the little bit of money I have, I really do not want to leave it to my children. I know this sounds awful, but
no, that's quite all right.
I have a daughter that lives in Seattle, and I really don't get along with her. And I have one here that is very taken care of.
So it sounds like you might need a will.
Well, I need a will because I want to leave my money. I want to make sure that that my ashes go to England, and I want to make sure that my other things go to animals.
Okay, so
can I?
Sure.
I'm sorry.
No, that's quite all right. We got it, Myra. Thank you so much. We'll go ahead and elaborate on that. Thank you.
Thank you.
Thank you, Myra. What a beautiful accent.
Yes.
Well, this is some fairly in-depth stuff. First of all, she's got no will, which means that if she passes away, absent beneficiary designations on things like bank accounts and insurance or whatever she does have, her children are going to inherit from her. Furthermore, this is the kind of case where we could anticipate challenges, so we better nail everything down. There is nothing more prone to a challenge than a case with a disgruntled, disinherited child. So we have all kinds. We better have a will. We better make sure that the formalities are taken care of. I often like, in a situation like that, to get a letter from the doctor saying that we have capacity to make the will, and we should probably have somebody with a local presence administering things to make sure that these children don't wean their way into this situation.
Yes, Myra, you're going to have to go ahead and get a will written up. Let's go back to the phones right now. We have Jim on the line from Carroll County. Jim, do you have a question? Hello, Jim?
A detailed will, about 5 years old, that incorporates a testamentary trust. I was informed that in Maryland, it's no big deal to go through probate, and so we set it up this way. Would you comment on that?
Thank you.
Okay, no big deal is sort of a matter of opinion. I would say that there are states where the probate process is far worse than Maryland. And under ordinary circumstances, and this is what I mean by ordinary circumstances, we don't have any family fights, we don't have any out-of-state assets, we don't have any difficult assets to value or sell, like a baseball team or an odd real estate parcel of some kind, then probate is fairly routine. It takes 6 months, a minimum of 6 months, to go through the courts, so it delays things. And if the testamentary trust, that's a trust that's formed under a will when somebody dies, is for the benefit of, say, a disabled person who may need immediate access to funds, or for a spouse, then you may want to consider avoiding probate. That's kind of what we use revocable trust for. But I would not disagree with the caller in that probate without these extraordinary outside agencies is just another proceeding.
Yeah, but one that could take a very long time, 6 months. Where should you keep your will, and why is it important to register it with the Register of Wills?
Okay, two different questions. First of all, let me tell you where you shouldn't keep your will.
Yeah.
You should not keep your will in your safe deposit box. That is the least accessible place. When I was young and didn't know much and my time wasn't valuable to my supervising partner, I spent lots of times going to the bank to convince the lady at the bank that we could get into the safe deposit box to get the will that would allow us to get into the safe deposit box. So it wasn't exactly, it was a nuisance. And here's another sort of a hot flash. When somebody breaks into your house to steal things, they're not stealing your will, okay? So the best answer is a fireproof box at the house. Now, there are opposing views on whether you should register wills. I have a partner that insists on registering wills, but then every time you register your will, which is just calling up the Register of Wills and taking it down there, every time you make a change, then you got to register it again. And that's kind of, you know, the registering of wills is really good when we think we might have unusual circumstances, like undue influence that'll make us do another will. You know, these, you know, back room at the middle of the night executions that leave all of it to you instead of to me, right?
But if everything seems like it's going to go smoothly, not so much. Kathy from Hartford is on the line. Kathy, do you have a question?
Yes, I have a home in Florida and a home in Maryland. I have 2 children that will be divided equally. My husband recently died. Do I need to have a will in Maryland and a will in Florida?
Okay, no, you don't need to have a will in both places. You should have a will that satisfies the formality of execution in both places. Maryland only requires 2 witnesses to attest to a will. Florida requires, if you don't want to have to prove up a will, you should have the attestation, the witnessing process notarized. Having said that, I think it would be useful for you to talk to your attorney about the use of a revocable trust in this case. That is the ideal situation for using one is when you would have a probate in Maryland for your Maryland real estate and a probate in Florida for your Florida real estate. By having a revocable trust where you transfer your property into the trust while you're alive, you avoid 2 probates, which is probably more useful than avoiding 1 probate.
That is amazing. Contesting a will, is that possible? And if so, by whom?
By everybody. Okay? By everybody who thinks they shouldn't.
Get a piece of the pie.
You know, when I taught at the law school, I started out every semester with the book. I said, you see this book? In this book, they have cases. They all have the same things in common. Guy died, guy had money, somebody unhappy about it, somebody challenges.
Right.
And clients will come in and say, I got to challenge that will. My mother must have been crazy when she made the will. She left me out of it.
Right.
Okay.
So then, but it's a big process. I'm going to see if I can squeeze in another call real quick so anybody can contest a will. Joan or Joanne from Worcester County on the phone. Joan, please go ahead. Joan or Joanne?
Yes.
Yes.
I have a revocable trust and I have a will, but my will is not notarized. Do I have to have my will notarized?
Great question. Thank you so much.
Really good question. The kind of will that the caller has with a revocable trust, incidentally, is called a pour-over will. P-O-U-R, over. And what it does is sort of backs up the trust. If you forgot to put the assets in your trust while you were alive, it adds those assets to the trust without avoiding probate. The answer to her question is, so long as she has the will properly witnessed and attested to in Maryland and does not have out-of-state property, she probably does not need to rush out and get it notarized.
Should husband and wife have joint wills or separate wills?
Separate wills.
Why is
Joint
that?
wills fell out of favor years ago. They are complex, they are unwieldy. Even the best practitioners have a little trouble understanding exactly what they mean or what they should do. They invariably don't offer estate tax planning if that's a necessity. Big believer, each spouse has separate will. Now, they can be reciprocal wills. They can be identical, mirror-like wills, but they should each have their own will.
What about PODs, payable on death? How does that apply? Because that could be something you may want to look into as well.
Well, yes, we always look at a payable in death beneficiary designation on bank accounts done by just going on down to the bank using their form, and it avoids. It also avoids probate. You don't have to take the bank account through the courts. They are great. I love them on checking accounts. Even when people have gone to the lengths of getting revocable trusts or doing special deeds, I like it so the checking account doesn't have to go through probate, for example. But we need to be a little careful. We got to make sure, and this is, one of my favorite questions from clients is, should I put my kid's name on an account?
Right,
okay?
right.
And that's one of like 5 ways you could do it. But you got to be really careful. You put your daughter's name on a bank account as a payable in death beneficiary, and your will says they share the other assets equally. Guess what? You favored one kid over the other because it's the beneficiary designation that rules. So you got to be careful to make sure that we've got consistency in these various tools.
In the last 20 seconds we have left, what recommendations, what last-minute advice or tips, you were wonderful throughout the show, that would you give to our viewers before they get started?
I would say a really good starting point is get a great list of your assets together, the titling, the ownership of the assets. I can't emphasize how important that is. Beneficiary designations, value, and then go see your attorney if you haven't done it in a long time.
Wonderful stuff. David Pessin from PK Law, thank you so much for your time. We appreciate it. Thanks so much. And we appreciate you watching, everybody. Have a good night.
This program was made by MPT to serve all of our diverse communities.